The ATF now faces a hard decision on whether or not they want the Supreme Court to review their unconstitutional bump stock rule and all of their other rules. So let's talk about this. But real quick, before we jump into this video, I want to thank the sponsor of this video, which is TacPack. TacPack is a subscription-based box that delivers tactical and EDC gear to your front door every single month. Every month, their team puts together an amazing box with a variety of products, various things for your range use, for your daily life, for your EDC, and other things as well. You can expect to get things like knives, outdoor equipment, mag carriers, cleaning kits, medical gear, AR rails, flashlights, ear protection, and a lot of other items as well. TacPack is amazing. It's one of those really cool things that I like to get every single month. And right now, if you sign up for a subscription with TacPack and you use the code ARMED, you will get a free grab bag along with your subscription. So I will leave a link down to TacPack down below if you're interested. And thank you again to TacPack for sponsoring this video. As I mentioned in the intro, in this video, we will be discussing a very important case and a very important decision that came out of the Fifth Circuit en banc panel. The Fifth Circuit en banc panel recently ruled in the case called Cargill v. Garland, and in that case, the ATF's final rule on bump stocks was found to be in fact invalid. In this important decision, the Fifth Circuit en banc panel found that the definition of a machine gun, as outlined in the NFA and GCA, does not apply to bump stocks. Therefore, they vacated the lower court's decision and remanded it back down to the lower court for reconsideration. However, this decision has major implications not just for bump stocks, but it will also likely impact other ATF rules and other ATF overreach, like the ATF's rule on frames and receivers and the new rule on pistol braces, which the ATF just dropped. This case is going to play a major role because now the ATF is faced with the decision on whether or not they want to appeal this or seek a petition from the Supreme Court to review what the Fifth Circuit en banc panel ruled. But as of right now, the ATF has not, but their time is actually running out. Now, the Cargill case involved a direct challenge to the ATF's rule, which suddenly regulated and banned bump stocks under the assumption that those items were now all of a sudden machine guns. For many years, the ATF had stated that the NFA and the GCA's definition of the term machine gun does not include devices like bump stocks. However, after the incidents in Las Vegas, the ATF, after being directed by then President Trump, decided to arbitrarily change the regulatory definition of a machine gun so that all of a sudden bump stocks would then be considered to be a machine gun. This new rule took effect in March of 2019, and therefore under federal law, owners were required to either destroy the devices or to surrender them to the ATF. This change in definition made possessors of bump stocks subject to punishment of 10 years in prison and or a fine of $250,000 if you fail to destroy or to surrender those items. This case, Cargill challenged that rule. One of the important aspects of this challenge was whether Chevron deference should be given to the ATF in relation to their final rule on bump stocks, or whether a different rule called the rule of lenity should be used instead. If you're not aware of what Chevron deference refers to, Chevron deference is a term coined after a landmark case referring to the doctrine of judicial deference given to administrative actions. Generally, for an agency to be given Chevron deference, the agency's interpretation of an ambiguous statute must be rational or reasonable. In contrast to Chevron deference, the rule of lenity indicates that when dealing with criminal statutory interpretation, a court is required to apply any unclear or ambiguous law in a way that is most favorable to us, the people, not an enforcement agency like the ATF. Well, in a 13-3 decision, the en banc panel in the Fifth Circuit found that the ATF did in fact overstep its authority. The court stated, "A plain reading of the statutory language, paired with close consideration of the mechanics of a semi-automatic firearm, reveals that a bump stock is excluded from the technical definition of machine gun set forth in the Gun Control Act and the National Firearms Act." So first they said that even on a technical basis on the mechanics of a firearm, there is no way that a bump stock could be considered to actually be a machine gun. But then they also went in and looked at other concepts like the tenderness of law and this whole issue of the rule of lenity. They pointed out that the government's regulation violates these principles. As an initial matter, it purports to allow ATF, rather than Congress, to set forth the scope of criminal prohibitions. Indeed, the government would outlaw bump stocks by administrative fiat, even though the very same agency routinely interpreted the ban on machine guns as not applying to the type of bump stocks at issue here. Nor can we say that the statutory definition unambiguously supports the government's interpretation. As noted above, we conclude that it unambiguously does not. But even if we are wrong, the statute is at least ambiguous in this regard. And if the statute is ambiguous, Congress must cure that ambiguity, not the federal courts. So that is very important language there. The en banc panel in the Fifth Circuit clearly identifies that the definition of a machine gun in the GCA and NFA does not include bump stocks. And even if the term were considered to be ambiguous or vague on that very issue, the court concluded that the rule of lenity would direct the interpretation in the favor of us, the people, not the ATF and their interpretation that bump stocks are in fact machine guns. If Congress or the ATF wants that definition to include those types of items, then they need to go into the statute, change the definition within the statute, but the ATF does not have the power to do that on their own. Now, currently, we are waiting to see what the government and the ATF decides to do. This Fifth Circuit en banc panel decision was issued on January 6th of 2023, and there are specific deadlines for a party to file a petition up to the Supreme Court for them to seek Supreme Court review or a reversal of the Fifth Circuit en banc panel's ruling. Under the Supreme Court's rules, you must file your petition for a writ of certiorari within 90 days from the date of the entry of the final judgment in the United States Court of Appeals or highest state appellate court, or 90 days from the denial of a timely filed petition for rehearing. That means that the ATF has until Thursday, April 6th of 2023 to decide if they want the Supreme Court to review the Fifth Circuit's decision in this Cargill case. Ultimately, in my opinion, I think the ATF has no choice but to actually seek review from the Supreme Court because they cannot have this precedent sitting out there, especially right now with the Fifth Circuit challenges to things like the ATF frames and receivers rule and also the ATF's pistol brace rule. There's a ton of cases going on right now in the Fifth Circuit that are trying to play off of Cargill. So the ATF really has no choice but to try to take this up to the Supreme Court. It's also going to be very hard for the Supreme Court to deny review of these cases because if they in fact deny cert, then the Fifth Circuit's decision becomes binding on all those lower courts in the Fifth Circuit. And again, that threatens the ATF's rules on bump stocks, frames and receivers, pistol braces, and anything else that they try to do. The Supreme Court will likely want to take control of the issue, take control of this precedent, and decide the case the way that they want to. Whether or not that will be positive, we really don't know. We will have to wait and see. But in my opinion, there is no way that the Supreme Court could avoid this. I think the ATF is going to have to seek review of this, and I think it's going to force the hand of the Supreme Court to finally have to address this issue of ATF overreach. So that is where the Cargill and bump stock case currently stands. Right now, we are waiting to see what the ATF does. They have a specific timeline for them to actually file that petition up to the Supreme Court. It's approaching soon, but my expectation is that they will still seek Supreme Court review. But if we get any more information, of course, I will let you all know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe, and never forget the station was built by armed scholars, and the station will be maintained by armed scholars.